Is Kyle Rittenhouse truly innocent? Did the jury come to a fair and correct verdict? Let's break it down. I'm Rachel King of King Law Firm Attorneys at Law Incorporated, and I want to talk to you about this truly sensational and groundbreaking case and verdict from a lawyer's perspective. I'm currently in a hotel room on Thanksgiving break, but this was so important that I needed to get to you now. Growing up in a family of lawyers and working in the field of law for almost 7 years now, I have come to a great respect for jurors and juries. In fact, every time I get jury duty, I hope and pray that I get put onto one. I think it would be a fantastic experience. Every juror that I've ever come in contact with, everybody that I've ever known that's been on jury duty, they want to make the right decision. They work really, really hard to make the right decision, and they do it because they represent the community. Juries and jurors are serious, they are intelligent, they take their job with dignity, and they use common sense in the case that they are on. And when they're given all of the information that we as the public are not privy to, the media filters it. Everywhere that we go, it gets filtered, but the jury sitting in the jury box watching every single piece of evidence, they get it, they get to see it, and honestly, they do it right almost 99% of the time. In the case of Rittenhouse versus Wisconsin, the jury had been given almost all of the information that they needed, right? Actually, I don't know that there has been a case where a jury had as much information as they did in this case. In fact, the entire incident was almost entirely videotaped, which gave the jury an opportunity to see what happened. And then you add the fact that Kyle decided to take the stand himself. Many defendants do not take the stand. Almost every defense counsel will say, please don't take the stand. Exercise your Fifth Amendment right not to self-incriminate. In this case, we had a defendant who took the stand, and he went on and testified over and over again. That's unbelievably rare. So it makes the jury's decision a lot, I don't want to say easier, but they have so much more information that, again, us as the public just simply were not privy to. Even though there was media in the courtroom, guess what those media news people get to do? They get to trim it and show it and filter it however they think is going to go best with their audience. The task on whether to find a defendant guilty or not guilty is a major decision, and it's not a decision that the jury takes lightly. It is not a decision of whether the defendant is a good person or a bad person. It is not a decision about whether the defendant should have been where he was or wasn't. Should Kyle have been there or should he not have been there? Was it appropriate for a 17-year-old to be there? That's really not the question that the jury is being asked to make. It's not a question about whether Kyle had certain positions when it came to racial minorities, police shootings, or political protests. And it really wasn't even about whether it was appropriate for him as a 17-year-old boy to bring a gun to this situation. The only question that the jurors were asked to be made was whether he, as the defendant, was the aggressor that killed 2 people and wounded 1 without cause, or was he acting in self-defense? And an aggressor is a person that attacks another first. It's important to note that while I'm not an attorney in Wisconsin, under Wisconsin law, deadly force is permitted if a defendant reasonably believes that force used was necessary to prevent imminent death or great bodily harm to himself. Reasonableness is to be viewed based on the defendant's position under the circumstances that existed at the time of the alleged offense. Another point that many people have made is that Rittenhouse provoked the attacks upon himself. And I'm here to say that simply bringing a gun to a rally does not actually count as provocation under the law. Again, this is not should he have brought the gun or should he have not brought the gun. It's really looking at something quite a bit better or quite a bit deeper than that. Did Rittenhouse reasonably believe that he was going to be killed or great bodily harm was going to be inflicted upon him? Remember, the prosecution must be able to prove beyond a reasonable doubt that Rittenhouse did not reasonably believe that he was going to be having great bodily harm or be killed in order to get a conviction. That's a tricky place. Beyond a reasonable doubt is super high. It's the highest standard that we have. It's much higher than preponderance of the evidence and clear and convincing evidence and some of the other legal standards. It is so high that in law school they don't even teach you a number. They'll oftentimes say preponderance of the evidence is greater than 50 or 51%. They don't even do that in beyond a reasonable doubt. It is a very, very high standard, something that is incredibly hard for the prosecution to prove in all cases. And we do that, why? Because we're taking somebody's liberty away. And we don't want to do that if we're wrong. We'd rather be let 10 guilty people off than convict one innocent person, right? Most people have heard that saying. Whether that's true or not is another story, but that's kind of the basis of our jury system. So in this case, the jury had all of the information. The jury had the video, they had all of the evidence, they had the defendant testifying, they had everything that we as the general public don't get to see, and they deliberated and they decided that the prosecution had not met their standard of beyond a reasonable doubt. And because they did find that it was reasonable for Rittenhouse to believe that he would have great bodily harm or be killed, that it was reasonable force for him to do that, and so they had no choice but to find a not guilty verdict. Another way of saying it, the prosecution did not prove beyond a reasonable doubt that Rittenhouse did not reasonably believe that he would suffer great bodily harm or be killed. So let's trust our juries. Let's trust our judicial system. I know this was a big case. It's still going on. It's causing a lot of upheaval in our already conflicting world, but let's trust our juries, and let's trust every single one of them that heard all of the evidence, because as a lawyer that has been in the courtroom and as a citizen who has talked to juries, they do their best and they hear so much more than we will ever know.